Hello again. It's David Wilkins from Minnesota, ASALH, and I understand that you all are studying the courts, the U.S. courts, and perhaps the state courts, the court system, in your continuing study of U.S. government. And I wanted to take a few minutes and just share some of my thoughts about a particular case and how that case has had great impact on our history, the history of our courts and of our country. The case is Dred Scott versus Sanford, and I'm going to, at a later time, also share some of my perspectives, the perspectives of an African American historian on Plessy versus Ferguson, the separate but equal case, and the Brown versus Board of Education case. So these are three critically important decisions of the U.S. Supreme Court that impacted our country, the history of our country, of our society, and had particular impact on its African American citizens. But I'm going to talk about Dred Scott v. Sanford. This is a critically important case for a number of reasons. Comically, I would tell you it is still perhaps the worst decision ever issued by any U.S. Supreme Court. And I think most historians, most legal scholars would agree. The case is important because it is another example of how important the courts are in our system of government. The case would ultimately rule, as we will see, and I'll share a short video in a moment and give you some more of the details, but essentially the U.S. Supreme Court in the period immediately before the Civil War will decide that Black people, both formerly enslaved and free, are not citizens and have therefore no rights that the courts nor any other citizen need respect. So that's I'll unpack that in a minute, and it's a powerful statement from any court, let alone the highest court in the land. But again, it reinforces the point of how important our courts are and the decisions of those courts, because it would have enormous impact. Ultimately, would be one of the key factors that would lead to the U.S. Civil War. The second point I make is that the concept of separation of powers, that each of the three branches of government, the executive, legislative, and judicial, have delineated powers, and that they are separate and that they act, in Madison's words, as a check on one another. That's true doesn't necessarily mean that they do not on occasion collaborate, and there's an interesting story associated with the Dred Scott case to make that point. Hip Hughes in the video will highlight that discussion, the interplay between Justice Taney and President Buchanan. Third point, judges bring their biases and prejudices to the bench, to their rulings, just as we all bring our biases and prejudices to everything we do in our lives. And it is a reminder to certainly a judge who takes an oath that they can set aside those biases and prejudices as they fulfill their responsibility. Taney, in my view, again, in the view of most historians, failed miserably to do that in the case of Dred Scott v. Sanford. Fourth point, courts, even the Supreme Court, don't always follow their own rules. There's a well-established rule in our court system, certainly in the U.S. Supreme Court and in the federal courts under that Supreme Court, that judges are supposed to follow precedent, concept of stare decisis. And arguably in the Dred Scott v. Sanford case, there was a path to resolution that would not have the broad impact that Justice Taney's sweeping decision had. And again, I'm suggesting it was such a sweeping decision that it was one of the contributing factors that would lead the North and the South to fight a bloody 4-year war with the loss of up to 700,000 men and women. Fortunately, the fifth point I'd make is that bad decisions can be corrected. And as we will learn in looking at Dred Scott, the Congress in 1866, in passing the first Civil Rights Act, would reverse Taney's ruling on citizenship, would in that act provide birthright citizenship for people of African descent born in America. And then the 14th Amendment, of course, would enshrine birthright citizenship in our society. So let me just say a couple of things about Dred Scott v. Sanford. Hip Hughes covers the facts of the case really, really well, but the essential facts are Dred Scott was born around 1800. He was owned by a man named Peter Blow. Blow would travel from his home in Virginia to a number of places in the mid 1800s, early 1800s, including free territory. Then the Missouri Territory, what is today Illinois. And he's going to die, and Scott will be purchased by an Army doctor named Emerson. Emerson would move to a couple of different postings as an Army surgeon, also in free territory. Now, Scott could have, as an enslaved person, because he's in free territory, could have made a freedom suit. And if you have the opportunity to study African American history more broadly than just in the context of this U.S. government class, you'll come to understand that freedom suits were in fact filed by enslaved men and women up until the time of the emancipation. And this was perhaps the best known freedom suit. He didn't do that until later, until he had in fact moved with his enslaver to Louisiana. Emerson would die, and his widow, Eliza, would refuse Dred Scott's offer to buy his and his wife's freedom. Scott will marry his wife before they move to Louisiana. So at this point, Scott goes to trial. What you need to know is he's living in St. Louis, Missouri. He will file a lawsuit around 1848 or thereabouts, and he'll win that case actually at the lower court level. And again, we're talking about state courts now, and I know you're probably looking at the state court and the federal court, but he's in Missouri. He wins that case, but the Missouri Supreme Court, probably because of the pressures of the pro-slavery environment. Again, this is just a few years before the Civil War. The Missouri Supreme Court will reverse that decision, determine that Dred Scott and his wife, Harriet, are not free. And he's going to now take the case with his lawyers to the U.S. Supreme Court. The three issues, as Hip Hughes is going to point out, the one is Scott a citizen? Does he have a right to sue as a citizen? Secondly, did his time in free territory make him free? And then lastly, the broader issue was, did Congress have the right to pass the Missouri Compromise, the Compromise of 1820, which barred the extension of slavery into the territories, and that was really the crux of the issue. So the Supreme Court, facing those three issues, could have narrowly resolved the case based on, as I said, precedents. There was established precedents that said an enslaved person taken to a free territory does not therefore become free. Tawney would decide not, in fact, to follow that precedent. And there's some suggestion that that decision was both his and the preference of President Buchanan. In their minds, they thought that this Supreme Court decision would in some way resolve the issue of slavery and therefore ameliorate the growing tension and violence that we now know was going to lead to the Civil War. So Tawney issues this broad brush decision, and he convinces three of the Northern justices. There's a majority of Southern justices, pro-slavery justices, and they have obviously an opinion now of the full court on these three issues that again we'll talk more about. I'm going to play the video, and then I'm going to end with some concluding comments. But before I do that, let me read you just a short passage from Tawney's decision. It's perhaps the best known language, the most offensive language, frankly, but it is the basis upon which Tawney makes his decision, and his stark racism is quite clear in that language. So this is from Tawney's decision in Dred Scott v. Sanford. He says, in part, Negroes had not been part of the sovereign people who made the Constitution, Tawney ruled. They were not included in the all men whom the Declaration of Independence proclaimed created equal. After all, the author of that declaration and many of the signers owned slaves, and for them to have regarded members of the enslaved race as potential citizens would have been utterly and flagrantly inconsistent with the principles they asserted. For that matter, wrote Tawney, at the time the Constitution was adopted, Negroes had for more than a century before been regarded as beings of an inferior order, so far inferior that they had no rights which a white man was bound to respect. Again, the most racist but best known part of that decision. Let me play the Hip Hughes clip here.
Hey guys, are you ready to go on an adventure of learning? Because I'm about to go on a safari of teaching. Well, maybe not so exciting, but we're definitely going to do a Supreme Court decision that you need to know if you're in an American history course or you're walking around on planet Earth and you like your history. And that would be the Dred Scott decision, or Scott versus Sanford of 1857. So we're going to kind of take a look back in history, guys, take a look at the facts of the case, definitely look at the Supreme Court decision and what the decision actually said. And then most importantly, we'll look at the effect of that decision, and we'll do some bang bang for the learning. So why don't you go get the door, because I think it's here. Go answer the door. All right, so let's go over the very basic facts of the case so we can understand what the Supreme Court decision is all about. Dred Scott was born around 1800 and around 1820, right at the time of the Missouri Compromise, which is going to be really important in this story. His owner, Peter Blow, takes Dred Scott to the territory of Missouri, which now is a slave territory. He is then sold, as a slave to an Army sergeant in the American Army, John Emerson. And John Emerson then ends up moving shortly after to Illinois. And Illinois, according to the Northwest Ordinance of 1787, comes into the Union in 1819 as a free state. So not only is Dred Scott going to be a slave in a free state for a little while, but his owner, John Emerson, is then going to take him to what was then the Wisconsin territory. Later was going to be, I guess, part of Minnesota. But either way, we're really testing the Missouri Compromise, because that territory, the Wisconsin territory, is free territory according to that line drawn out by the Missouri Compromise in 1820. What ends up happening is around 1837, I believe that Emerson goes back to Louisiana. He's in the Army. He ends up dying, I believe, in the Seminole War with the Native American tribes down in Florida, somewhere around there. But his wife, Eliza Emerson, actually leased out Dred Scott and his family in Wisconsin for a little while, and then ended up bringing the family back to Louisiana, and then ending up in Missouri. And I know along the way, Dred Scott had a child named Eliza that was born in the Mississippi, and that child was born in free territory as well, which just kind of adds to the mix of the story. And what ends up happening is the state of Missouri, in the court case Scott versus Emerson, because remember, his owner was Eliza Emerson, ended up finding that Dred Scott was still going to be a slave, even though Missouri precedent, kind of previous decisions, had favored emancipation in these incidences. Because slavery has become such a hot topic with the expansion issues and the compromise issues of 1850 and the Missouri Compromise, Missouri is basically claiming, slaves back. Once you're a slave, if you come back, you're going to be a slave. And remember, we also have the Fugitive Slave Act on the front burner as well. So at this point, Dred Scott is going to turn his attention to the Supreme Court. And at that time period, I believe that Emerson, the wife, had transferred custody of Dred Scott to a new owner, who would be Sanford, John Sanford, who was Eliza's brother, who was a citizen of New York. And that's actually important too. But now you have it. You have Scott versus Sanford, Dred Scott versus his owner, John Sanford. And the Supreme Court trial begins. Ding, ding, ding. Let's keep going. All right, guys, so now we're at the Supreme Court. This is a federal trial now, and we have Scott versus Sanford. 3 questions are being tossed around by Roger Taney, the Taney Court, the Chief Justice, and the first one is that of jurisdiction. Does Dred Scott, as a citizen, as he sees it, of Missouri, have a right to have standing in this court case? According to Article 3, Section 2, if you're a citizen of one state and you have a lawsuit or a pending suit against a citizen of another state, that can be a federal court hearing. You could have a Supreme Court case on that. The second question will be that of whether Congress has the constitutional ability to regulate slavery in the territories, i.e. is the Missouri Compromise and even the Northwest Ordinance of 1787. Does that pass constitutional measure? Can Congress limit the scope of slavery in these new states? And then finally, is Dred Scott free? Is Dred Scott free if he left and stayed in a free state and now he's returning to a slave state? So I think what's important to understand as we go out and explain these decisions is really the context of the times. James Buchanan, who was elected president as the Supreme Court was hearing this court case, and remember, there's a long lame duck kind of session. So he's elected in November of 1856. He's not going to take office till March 4th of 1857. So in that time period, there is evidence that Buchanan was talking to Supreme Court justices. There's evidence that Robert Cooper Greer, one of the Supreme Court justices from the North, was having correspondence with James Buchanan because James Buchanan wanted this issue settled. And he wanted a Northerner to side with the majority on the court so it didn't look like it was a sectional decision, because he doesn't want to deal with this issue anymore that he sees as ripping kind of the country apart, this issue of slavery. He wants the Supreme Court to make a decision and close the door so the country can move forward with slavery or without slavery, but he sees it as with slavery. So here's the awful decision. It's a 7-2 decision. Number one, they state that Dred Scott's not a citizen, that this is really racist language they use. They go back to kind of writings and ramblings of the founding fathers talking about the white race being superior and that Negroes and their descendants have no claim to citizenship, that they might be emancipated in certain states, Taney says, but they don't have citizenship rights. And therefore, they don't really even have the legitimacy to bring this to trial. So therefore, the suit is basically dismissed. That's probably where it should have been. If it stayed there, it still would have been a terrible decision, but there would have been no precedent set. There would have been no kind of pushing the nation into kind of a iron clasp decision on slavery one way or the other. But then the Taney Court goes on to say that the Missouri Compromise, that Congress's ability to regulate slaves kind of issues in the territories is unconstitutional. This is only the second time that the Supreme Court is using its power of judicial review to find a federal act, a congressional act, unconstitutional. The first one being Marbury versus Madison. And now here we are, I don't want to do the math in my head, 40, 50 years later, and the Supreme Court's doing it again, but this time on the Missouri Compromise. And that's going to have humongous effects. And also, by saying that, the Northwest Ordinance of 1787 is also going to be unconstitutional. Now, we're going to talk about the effects in a second, so I'm going to save myself. But the third issue of whether Dred Scott is slave or free, they basically state that since we have no right to hear this court case, that the standing in Missouri, when it was Scott versus Emerson, stands, that he is a slave, and we ain't going to do nothing to change that. So there you go. You have the most terrible decision in the history of the United States in the Supreme Court. Now, most importantly, you want to remember kind of the basic idea if you're taking a test in the morning or something like that. They said slaves are property, that slaves are property, and that the owner's decision to bring that slave into a free territory and then come back, that's still their property, and that no legislative act by Congress is going to change that. So we basically pushed the country now to the next level, and let's take a look at what that next level entails. All right, the effects are big time. First of all, I think it's really telling that Roger Taney, the guy who made this decision, is seen whispering into President-elect James Buchanan's ear on March 4th, the inauguration day of 1857, basically saying, yo, bro, we got this thing locked in. These two knuckleheads, Buchanan and Taney, think that this decision is going to kind of sew this nation back together, and that the Civil War, which might have been unavoidable, will now be avoidable because of their mastery of judicial review. Of course, the decision is going to have the complete opposite effect. And 2 days later, on March 6th of 1857, the nation kind of enters into the final phase, moving towards the Civil War. Number one, it's going to piss off abolitionists. Like the John Brown raid is what? The next year? 2 years later? And I'm sure John Brown, when this decision came out, probably made the mental decision, that's it, I'm done. And of course, you also have Southerners who feel emboldened too. And they're even thinking about trying to overturn decisions that would allow them to bring their slaves to New York City, and seeing the possibility of slavery now basically being everywhere. And of course, that's going to scare the hell out of the North. You also have to remember, guys, that if slavery is going to expand out west, and the Dred Scott decision is going to allow that, that you're going to have more of a slave population, hence the census is going to be affected. Remember, the 3/5 compromise back from the olden days of the Constitutional Convention is going to kick in, and therefore, for every 5 slaves, you're going to get 3 reps for that state. And if it's a slave state, obviously that's not good for Northern interests. This leads also to really Lincoln, I think, taking a firmer stance on the issue of slavery with his nation divided speech, really mentioning the Dred Scott decision and how dangerous this is for the Supreme Court to really kind of mute the legislative and executive branches from dealing with this issue. And at the same time, I think emboldening the Republican Party to take a firmer stand on this idea of free soil and this idea of slavery not being left into the territories. And I think that, combined with John Brown, and now combined with the election of Abraham Lincoln in 1861, him taking office, is going to lead to the direct secession of those southern states into the Civil War. So to end this story kind of with a circle, we'll go back to the beginning. Peter Blow, the original owner of Dred Scott, after the Dred Scott decision, purchases his former slaves' freedom, his emancipation. Dred Scott then ends up living in St. Louis. He died, unfortunately, 18 months after this decision. But the decision is going to be the bang bang for the Civil War. And now you know the Dred Scott decision, Scott versus Sanford, guys. What you going to do when the learning comes for you? I'm done with the teaching. We hope you did a little bit of the learning.
All right, let me get back to my slide. Let me stop sharing here. All right. Again, Hip Hughes does a great job giving you the facts with a bit of humor. A couple of finishing points here. He mentioned John Brown and maybe the best known abolitionist, but clearly the Dred Scott decision fired up anti-slavery abolitionists all over, certainly all over the North and across the country. The emboldened enslavers saw Dred Scott as gold. They clearly wanted, as we've said in some of these previous videos, the slave owning South wanted more land wherever they could find it, certainly in the West, in the Southwest, to expand their cotton kingdom. There's no question about that, and therefore is going to make a peaceful resolution all the more difficult to reach. Lincoln did indeed become more anti-slavery. He was never an abolitionist, but he said he always hated slavery, and he would be given the oath by Tawney as Chief Justice for his first inauguration. And so you can imagine that interesting exchange on the podium. So let me apply this a bit to I guess today. We've heard a lot in the just past election about the Supreme Court. We had the appointment late in the process of Amy Coney Barrett to the Supreme Court, and ever since the conclusion of the election, we've heard the current president, Trump, looking for ways, asking for the court to intervene. I believe his expectation was that the Supreme Court would in some way keep him in office. That may still be his belief, but if our system holds, that won't happen. There is no case that can be brought, because all of the cases that President Trump's lawyers have filed have been thrown out of court across the country as baseless and without merit. So if the cases can't get beyond the district court level to the appellate court, they're certainly not going to get to the U.S. Supreme Court. And then lastly, when we think about this Dred Scott decision, think about the words that Tawney used. Those words have great import. Words from powerful people do impact the culture. Yes, we're talking about the culture of the 19th century, the antebellum era, the Civil War and after, but it was thinking like Tawney's that would proceed through the generations, and I would argue still struggles. We still struggle with the import and impact of that language today. If we ever doubt that institutionalized racism is a reality, Dred Scott v. Sanford is a perfect example. And then there are a series of decisions that would precede it, and also would continue to build on this really racist attitudes of too many powerful people in our history. I've said I'm going to come back to you, and we'll talk about Plessy versus Ferguson and Brown versus the Board of Education as you continue your study in the U.S. court system. So I hope you appreciated this, and look forward to seeing you again.